Hey everyone, my name is Ryan Locke. I'm a criminal appeals lawyer in Atlanta, Georgia. And I want to talk to you about filing a motion for reconsideration after the court has issued its opinion. So we're talking about near the end of a direct appeal. The Court of Appeals or the Supreme Court has issued its opinion. There's a 10-day clock for them issuing the remittitor, which is when they send it back to the trial court. And you have that 10-day period in which you can file a motion for reconsideration. If you're in the Court of Appeals, you can file a petition for cert with the Supreme Court, but I'll talk about that in a different video. Here, we're talking about the motion for reconsideration. Now, the motion for reconsideration is what it sounds like. You're asking the court to reconsider their decision because of something. Now, a lot of times we don't file these motions because there's nothing for us, there's no argument that the court should reconsider its decision other than we think they're wrong because they didn't agree with us. If we file a motion saying, please reconsider, and then we just restate our brief, that motion's going to be denied 10 out of 10 times. Because the court has already considered all of our arguments and found them to be not persuasive. And that's why they're not deciding with us in an opinion. The situations where we would file a motion for reconsideration could be, one, this is rare, but sometimes it happens, where we read the opinion and we see that the appellate court has really misconstrued or gotten entirely wrong a fact from the record. Now, this is very uncommon because our appellate courts are careful, but every once in a while someone makes a mistake, and the record is clear that the light was red, but the appellate court somehow believes that the light was green, and they base their opinion on that. Well, we have a responsibility to say, hey, look, guys, you thought that you thought that the light was this one color, but the record clearly establishes that it's not, and we would ask that you reconsider your opinion based on the record. Again, really rare. What's more common is something changes in the law between when we've argued the case and when the opinion is released. Now, if it's early enough in the process, let's say that we argue a case, and then 2 days later, the Supreme Court of the United States comes out with a decision that completely changes the law in an area, and now we win. Well, we'd ask the court for permission to file a supplemental brief. We'd do a motion for leave to file a brief, and then we'd file a supplemental brief incorporating that new law, talking about the new case, and explaining how, now that that new case has been decided, the court should agree with us. Sometimes this happens late in the game. Maybe the Supreme Court decides that case, and then the next day, the Court of Appeals issues an opinion against us where they really should find for us based on this recent law. Obviously the opinion had already been written, it was in the hopper to be published, and it was. That's a good example of a time when we should file a motion for reconsideration and point the court to the new law and say, hey, here's some new law that didn't exist when you were writing your opinion, but now it does, and we win because of it, so please reconsider. Another situation, and this happens in our Court of Appeals, is the Georgia Court of Appeals is made of 3-judge panels. And when your case gets assigned to the Court of Appeals, you just randomly get assigned to a panel. And so it can happen, and it does happen, that similar sets of facts get presented to the Court of Appeals, and different panels decide the issue in opposite ways. So we may have two very similar cases, right? Different defendants, but similar factual scenarios. And one panel says the state wins, and another panel says the defense wins. Well, you may want to file a motion for reconsideration and say, hey, last week a different panel said that the defense wins, but this week you said that the state wins, and so we want you to reconsider your opinion in light of the other panel's decision and the arguments that they found persuasive there. This would also be a good situation to apply for cert, which we'll talk about later. I hope you enjoyed this video. I hope you learned something about when it's appropriate to apply, when it's appropriate to file a motion for reconsideration after the opinion's issued, and when it's not. If you enjoyed the video, please like, subscribe. I really appreciate you watching and learning about Georgia criminal appellate law. Thanks.